Welcome to the Best Practices for Charities During Pandemics and Disasters webinar. During disasters or pandemics, such as COVID-19 and wildfires, charities are called upon more than ever to meet the critical needs of our communities. In this webinar, we will review some best practices and rules to maintain proper governance and continuity in operations during challenging times. During critical times, you may want to avoid sending paper submissions to the registry by mail. Think about renewing your registration online. If your charity's registration status is current and you want to renew your registration, you can use the online renewal option on the registry's website. Please go to the charity's homepage and view the annual registration renewal webinar, Electronic Submissions for Instructions on how to renew online. For more information, please review the webinars posted on the registry's website and use the program email boxes to submit questions and outstanding documents. Make sure that your charity is lawfully operating in California. Unless exempt by law, charities must be current in their registration and reporting requirements to be considered in good standing. Many grant funders will not accept your grant request if your charity is listed as delinquent or suspended on the registry's website. Search the registry's database for your charity's registration status and also find documents and correspondence submitted to the registry by using the verification search tool. Go to oag.ca.gov, select Charities, and then select Registry Verification Search. You can search by using the charity's name or registration number in the appropriate field, and click the Search button. Once you select your charity profile, you can view its registration status in any documents on file. This is a great way to view correspondence from the registry or the latest submission from your charity. You should also make sure that the charity is compliant with all reporting requirements of the California Secretary of State, the Franchise Tax Board, and the IRS. The Board of Directors needs to continue to exercise control over the affairs of the charity, even in times of trouble. Your board should continue to meet regularly, review and approve budgets, review and approve compensation paid to high-level employees like the CEO and CFO, and avoid any conflict of interest with the charity. Charities should be fiscally responsible and maintain sufficient funds for day-to-day operations. That includes making sure your charity does not spend more than it has. Unexpected costs and emergencies arise, so it's wise to put aside funds for a rainy day. Making improper loans or distributions can subject a director to liability, even if the director abstained from voting to approve such actions. Also, directors need to exercise prudence in investing the charity's assets. For more information on best practices, please review our guide for charities. Even during difficult times, your board should continue to have regular board meetings and keep minutes of those meetings. California law provides that during times of crisis, meetings can be held remotely via video conference or conference calls. Likewise, California law gives the board the ability to draft board minutes at a later time, provided that there are contemporaneous notes taken during the meetings that can be accurately transcribed later. For good governance, it is important to maintain records and keep accurate accounts of your charity's finances and activities. The California Corporations Code has specific provisions for corporate governance in an emergency. Unless prohibited by the charity's bylaws, your organization may be able to give notice of director meetings in any practicable manner, have board meetings by phone or video conference calls, relocate the principal office, modify the lines of succession to accommodate the incapacity of any director, officer, employee, or agent. Note that the board cannot take action that requires the vote of members or take action that is not in the corporation's ordinary course of business, unless the required vote of the members was obtained before the emergency. For more information, please visit the Registry's publications and view the Governance During COVID-19 Pandemic publication. Directors can take action without a board meeting if all directors consent in writing and the quorum requirement is met. The written consent of the directors must be kept with the minutes of the board proceeding. Please note that directors cannot vote by proxy. Unless prohibited in the bylaws, and when authorized by the board of directors, members of a charity may hold meetings, in whole or in part, and vote through electronic transmissions or electronic video screen communication. For a meeting of members to be conducted through electronic transmission or electronic video screen communication, the charity must implement measures to provide the members with a reasonable opportunity to participate and to vote on matters. This includes an opportunity to read or hear the proceedings of the meeting and keep records of the votes and actions taken at the meeting. Endowment funds are donor-restricted funds. These funds typically require that the charity only use the interest and not touch the principal so that the gift can provide support for many years. Endowments are subject to the requirements of the Uniform Prudent Management and Institutional Funds Act found in the Probate Code. Charities need to be prudent in how much they spend from their endowment fund. Spending more than 7% of the fair market value may create a presumption of excessive spending. While your charity may be tempted to look to endowments to address budget shortfalls, a charity should not invade the principal or borrow against the principal. But a charity always has the option of contacting the donors to inquire whether they are willing to release or modify restrictions to allow for more spending authority. For endowment funds that are older than 20 years with total value less than $100,000, a charity may release or modify the restrictions after giving 60 days written notice to the Attorney General and to the donor's last known address. The charity must show how the endowment has become unlawful, impossible, impracticable, or wasteful to operate with the restrictions. The notice should also propose an alternate use that is consistent with the charitable purpose expressed in the gift instrument. For an endowment with over $100,000 in funds, charities may seek court approval to modify restrictions. The Attorney General must be given notice of the petition. The charity should hire a lawyer to file the petition. Notice to the Attorney General can be made to the following addresses based on the physical location of the charity. Your charity should be proactive in communicating any changes in address or other contact information. Be prepared to meet filing deadlines and communicate with the registry if you need extensions of time for submissions or payments. If you plan to merge, dissolve, or sell most of your charity assets, please review our guide to charities or the registry publication, Nonprofit Transactions Requiring Notice for Attorney General Approval. Please beware of false rescue plans. We have had several investigations involving fake rescue schemes during disasters. These schemes involve fake checks, unknown but very generous donors with extensive stories that typically want a refund before their check bounces. The board needs to be prudent in its management even during stressful times. Tragedy unfortunately attracts scammers ready to take advantage of desperate situations. If the proposal is too good to be true, it usually is, and your board needs to exercise caution. You don't want to make a public crisis into a personal tragedy. Also, be wary of fundraisers offering long-term contracts that may put your charity in debt with no net returns. Charities should pause before hiring fundraisers that fail to deliver positive results over the years or that have no experience fundraising. Make sure you are fully aware of the resources provided by the Registry, such as the Attorney General's Professional Fundraising Report, which lists commercial fundraisers and how much they have raised in the past for charities. Some of the worst performers are listed in this report. You can also review the model contract and the fundraising webinar on our website. Plan for the continuity of your charity beyond its current leadership. Avoid attaching essential functions to officers who may come and go without a backup plan. Make sure that the charity can survive staffing and officer changes. Maintain good record-keeping practices to prevent loss of records. Consider moving data online to a shared drive that can be accessed remotely. Finally, consider obtaining a P.O. box for mail from the Registry in case of an emergency where the physical address cannot be accessed by directors and officers. If you have any concerns about a fundraiser or suspect a scam involving fundraising for disaster relief, please file a complaint with our office using the CT9 form that can be found on our website under the Complaints section. This concludes the webinar. Thank you for listening.